Oh, just right. Sure. Oh. How are you?
Good morning, members and colleagues. Chiefs is just joining the platform shortly. We'll commence in the next 2 minutes.
Good morning, Ms. Solomons.
Good morning, Clay.
It's the start of the 9 o'clock load settings, so I had to try and hotspot. Good morning, honorable members. Good morning to the minister and the senior official from the Department of Trade, Industry and Competition and its entities, the staff of the committee, also the staff of Parliament, the
Recording in progress.
Advocate Ibrahim from the Constitutional and Legal Services Office. Not sure if we have a representative of the Office of the Chief State Law Advisor, Chief State
Yes,
Law
Chief.
Also greetings to the representative. Today, honorable members, we are receiving responses from the ministry and the department on the submissions, oral and written submission that were made by the stakeholders. We will be hearing from the minister how they are responding to those submissions that were made by the submitters. We have invited, I don't know if maybe some of them are here, as a part of the public participation process. We invited mainly those and also general, the people that submitted their views also to be part of this process throughout. Though they will not be participating, they will be observing the process throughout until we finalize and adopt the report. they are also welcome to attend the plenary session and see for themselves when we debate the bill in the plenary session of the National Council of Provinces. Can we just check those who are present and also if there are any apologies?
Okay. Thank you, Chair. Chair, in terms of attendance today, we have yourself, Honorable Dango, Honorable Moimang, Honorable Mashodi, Honorable Mamarahane, Honorable Lunt, Honorable Boshoff, Honorable Brautesev. In terms of staff, we've got my co-committee secretary, Ms. Dimizulu, our content advisor, Mrs. Ishuba, our researcher, Mr. Hanif, our committee assistant, Mr. Bazir. We also have our parliamentary legal advisor, Advocate Ibrahim, and the state, the representative from the state law advisor, Advocate Claude Blum. We have no apologies, Chair. We received no apologies, except one from Ms. Mashuri, who might be leaving a little bit later, but then coming back.
Thank you so much. Without wasting any time, I will then hand over to the minister. The minister will also indicate the team that he is leading. Over to you, Honorable Minister.
Well, first, thank you very much, Chairperson. Good morning to you, as well as to all the honourable members of the committee. Good morning to the officials from Parliament and from the Department. I'd also like to greet all the other representatives and persons who are on the platform. Chairperson, can I start by first appreciating the opportunity that the committee has given us to respond to public comments. And I would in particular like to appreciate the flexibility that the committee has shown in accommodating the starting time of the meeting. As Honorable Khai knows, because he's just returned from Abu Dhabi, and he was taking part in a global parliamentary engagement here. We are in the middle of trade negotiations at the World Trade Organization's 13th Ministerial Conference. And there are a number of issues that are important to South Africa that we are dealing with at the moment. And I do appreciate very much that the time was shifted. I'd also like to thank the committee members who have been engaging on matters of the two companies' bills, and for the thoughtful questions and the approach that committee members have raised. So thank you for that. Chairperson, I start with the observation that the attendees from our side includes on the first side on the platform, Professor Michael Katz. He is the chairman of the Specialist Committee on Company Law. It's a statutory committee set out in the Companies Act, and it has the duty to provide the ministry with advice on matters relating to the legislation. I'm also joined by officials of the DTIC, led by DDG Evelyn Masocha, who I think members of the committee would know, and Desmond Ramabulana has also joined, and there may be other officials that join in the course of the meeting. We, of course, have the ministry team that is also joining us. Honourable members, when I presented the two bills to the Select Committee last year, I provided a detailed history of the development of these bills. I highlighted the three pillars of our philosophical and policy objectives, and I noted the three prime categories of the policy objectives. Members may recall that I had made a presentation in PowerPoint form, and we identify each clause that was proposed to be changed. We set out the problem that we identified, what the proposed solution was, and the effect of the change. Now, where a submission to the Select Committee has been made by public representations that makes a point or raises an issue that is covered by the presentation, I will not repeat the points that were made in the presentation. The public comments received by the Select Committee, Honourable Chairperson, is now the fourth set of public comments on the Companies Amendment Bill. This is a testimony to the process that was undertaken. First, in 2018, when the very original bill was published, we got public comment. Then in 2021, there was a redrafted bill that was published, and I felt it appropriate to get public comment again before proceeding. In 2023, the Portfolio Committee published the bill, and the department was able to respond. And now finally in 2024, we've received submissions when the Select Committee published the bill. I also want to recall that the larger and more comprehensive of the two bills, namely the Companies Amendment Bill 2023, was subject to a very detailed engagement with representatives from both the business community, represented via BUSA at NEDLAC, and with organized labor. Unusually and very positively, honorable members, the parties were able, through very detailed engagement, to find common positions on most areas in the bill, including on some of the most significant policy areas. Now, they were only able to do that through very carefully crafted compromises that still respected the underlying principles that we sought to advance in the bill. What is striking about the public comments that was received, both the written ones and a number of the oral submissions to the Select Committee, and indeed the Portfolio Committee too, but certainly in the Select Committee, a large number of the proposed amendments were supported, with much of the debate really concentrated around matters of remuneration. There were also technical changes that were proposed. I will today focus on those representations that covers matters that form part of the amendment bill or are consequential matters. There were comments that fall completely outside the scope of the bill. And as honourable members know, that in terms of parliamentary conventions, we would not ordinarily deal with those matters. They would require a separate and a new bill. As one can anticipate with a reform on such important matters as set out in the two bills, there'll always be, as in any democracy, differences in views. You're not going to get to a point where we could ever develop a bill that everybody agrees with. In a number of cases, when I looked at the submissions, they set out the arguments for retention of the status quo in the existing legislation. But many South Africans are not happy with the status quo, for example, on remuneration. In other cases, when I look at the submissions, it's a matter of judgment, how extensive the reforms should be. And there'll always be views. There'll always be a view that says the reform has gone too far, can't you cut it back a bit? There'll also be views that says the reform has not gone far enough, can you go further? These are matters of judgment and policy balance. In addition, it will be readily appreciated that the task of drafting is not a precise science. It's not a binary of right or wrong. There'll be many different drafting styles and many concepts that are capable of being drafted in different ways. So I take that into account, and where a submission simply proposes a different drafting style, the department it would not support that, given that considerable time has gone into crafting it in the way that is proposed in the bill. It's gone through a number of iterations. It has had the broad support of the business and labor communities at NEDLAC. And where changes are purely cosmetic, we have not also supported those changes. Because we've had a very wide scope of the comments that were received, I want to focus on some of the more significant matters raised, particularly the policy matters. And I have the department officials and the advisors available to respond to any of the detailed comments received, where the committee believes that those comments were of sufficient magnitude, that they're not covered by my comments, that they're not covered by the comments that were made in the committee and in the PowerPoint presentation last year, that they've not been covered in the document that was submitted today. We really would be we'll be at the service of the committee in responding to these. I want to appreciate the opportunity to do a response document. I would have wished that it come out a little bit earlier, but thank you for being so so kind and generous about it, Chairperson. May I then deal with the submissions? The first area is disclosure and confidentiality, and there were quite a few submissions that covers aspects of it. I will start with sections 26.2 and 30A, dealing with confidentiality and with privacy. One of the themes that were contained in some of the submissions raised concerns whether we were breaching privacy through some of the proposed amendments, particularly those relating to private companies. And some of the concerns included access to annual financial statements. The concerns span privacy considerations, competitively sensitive information, and safety and security concerns. I want, however, to draw attention to the architecture and the philosophy of the current Companies Act, insofar as it deals with the distinction between public and private companies. As regards transparency and accountability, there is no reason for any distinction to be made between, on the one hand, publicly listed companies and state-owned companies, and on the other hand, private companies whose public interest score exceeds the statutory threshold, and for which, let me call them larger or significant private companies in my remarks today. These larger or significant private companies currently, in the existing legislation, have the same duties of accountability and transparency as public companies, or what we could call publicly listed companies also, and state-owned companies. Many private companies that exceed the public interest scores are large. They're often comparable with, or they're even larger than some of the public and publicly listed companies. So in our view, honorable members, they should have the same duties of accountability and transparency where these are relevant to public interest goals. This is also one of the reasons why there is no longer any limit set for the maximum number of shareholders that may be permitted for a private company. Therefore, there's no sensible reason for a regulatory dichotomy between public companies, state-owned companies, and larger private companies. Some submissions have argued that a number of requirements proposed should only be applicable to companies that are listed on the stock exchange. From a policy point of view, this would be a challenge. Honorable members will know that our company legislation in South Africa regulates all companies irrespective of whether or not they are listed. Of course, there are listing requirements separate to the legislation by our stock exchange. And they, for obvious reasons, can always impose their own requirements that go wider than what is set out in the statute for companies that enjoy the benefit of a public listing. So I really want to emphasize that all companies have obligations of transparency and accountability, which derive from the benefits that they get from their specific juristic personality status. Honorable members, I can leave the argument there because it's conceptually an argument that fits with the architecture of our Act. But I would also like to take the committee through the jurisprudence on the matter. We have a number of celebrated judgments in our top courts that illustrates the point that I've made. Kentridge AJ in the State versus Coetzee and others, which was a constitutional court matter, concluded that, and I quote, those who carry out, or those who choose to carry on their activities through the medium of an artificial legal persona must accept the burdens as well, unquote. In Bernstein versus Bester, the Constitutional Court held that, and I quote, the establishment of a company as a vehicle for conducting business on the basis of limited liability is not a private matter. It draws on a legal framework endorsed by the community and operates through the mobilization of funds belonging to members of that community. Any person engaged in these activities should expect that the benefits inherent in this creature of statute will have concomitant responsibilities. These include, among others, the statutory obligation of proper disclosure and accountability to shareholders. Honorable members, in the same case, the court also said, and allow me to quote again, and it's an extensive two quotes that I wanted to bring to the attention of the committee. So the second one says, quote, it is clear that any information pertaining to participation in such a public sphere cannot rightly be held to be inhering in the person, and it cannot consequently be said that in relation to such information, a reasonable expectation of privacy exists, nor would such an expectation be recognized by society as objectively reasonable, unquote. Chairperson, in Nova Properties versus Cobbett, the Supreme Court of Appeal noted that Section 7 of the Companies Act listing of core objectives of the legislation gives specific recognition to a culture of openness and transparency. And the SCA stated in Nova Properties, and let me quote, this is the last quote that I wanted to bring to the attention of the committee. It says, Section 26 of the Companies Act is enacted with precisely these objectives in mind. It recognizes that the establishment of a company is not purely a private matter and may impact the public in several ways. It therefore seeks to impose strong rights of access in respect of very specific, but ultimately limited types of information held by companies. Section 26 must therefore be interpreted in accordance with this purpose, unquote. And the purpose, of course, is set out in Section 7 of the Act. I hope, honorable members of the Select Committee, that this sets out the broader rationale for greater openness, that it addresses concerns about privacy, and that it provides the justification for requiring private companies to make certain kinds of information broadly available. The suggestion that there is no valid policy reason for disclosure of names in the context of remuneration is, with respect, flawed. The inclusion of names is a necessary component of adequate disclosure. Assume, for example, that a particular director or prescribed offer receives a remuneration which is manifestly inappropriate for that person. Shareholders are entitled to that disclosure for the purpose of objecting and for inquiring whether there is any compelling reason to justify the remuneration. For interest, we note that in terms of UK company law, both what are called quoted and unquoted companies have a duty to prepare a director's remuneration report. I am advised that according to Schedule 8 of the 2008 regulations to the UK Companies Act, the information required to be shown in the report or in respect of a particular person must be shown in a manner that links the information to that person identified by name. So following consideration of the various proposals made both by the interveners who sought to strengthen the proposed provisions, as well as those who sought to moderate them, the department concludes that the provisions in the bill as they currently stand before the Select Committee, dealing with confidentiality and privacy, need not be amended further. Chairperson, allow me to now address more specifically remuneration, and I want to talk to Section 30, capital A, where a number of submissions to Parliament was made. Some of them question whether the proposed amendments or remuneration will really be effective.
Can I suggest, Honourable Minister, after the document be flighted that you're talking to?
So, Chairperson, the document itself follows the one that I have submitted. These are really I'm just talking now through some of the key ideas. They are more of a general nature, and they supplement the document that we submitted last night. So they constitute my talking notes to the committee. So I made the point to the committee in the presentation that I did last year that we've grappled quite a bit with how to set out remuneration appropriately. There were a number of options open to us, Chairperson. And one of the options available to us was that we make the bill very prescriptive. We set out the maximum remuneration differentials in legislation. So we could say for a particular sector, this will be the maximum. That was one option. The second option is that the bill sets out a non-binding guideline in legislation. So we could do it either in the primary legislation or we could do it via regulations. The third option available to us was that the bill sets a requirement that we report the differentials in a company and require that the remuneration policy be approved by shareholders. And of course, there was another option available, and that is that the bill is silent on income differentials. So we could have taken any of those. The bill before the committee selects the third option, namely to have a reporting requirement in legislation itself. So that's the bill before the committee. And why did we go this direction, Chairperson and honourable members? We did so because we had, after a very lengthy engagement at NEDLAC, where organised labour had a much more extensive proposal that they wanted in the bill, and the business community had a very different approach to labour. They finally moved closer to each other, and government also put forward a number of views. And what came out in the bill received the broad support of both business and labor representatives. And in fact, Chairperson, in a number of cases, they helped to craft the language itself. And it focuses public attention on this great concern of inequality and these very high salaries, while leaving flexibility to company boards where they believe circumstances require it. As I indicated in the presentation that I made last year, there were these lengthy interactions and discussions, and when we got to the acceptable dispensation, we felt we would table this in Parliament. Now, the legislation is a signal of concern by the executive and the legislature, if it is passed, that we think it wise that boards take account of these provisions. At the least, the provisions will provide a more objective and factual account of wage differentials as a whole. We can, of course, then begin to compare between sectors. We can compare, indeed, between competitors in a sector to see is there any rationale. Now, the question can be asked, Chairperson, what if those measures don't have the desired effect? What if we don't see boards rising to the occasion and addressing the challenges that society has put forward? Parliament in future may well then consider additional measures, but we have put forward a particular approach that is based on seeking to get a public disclosure, what can be called the sunlight on remuneration gaps. Let me go next to the issue of the shareholder vote. We've taken note of the concerns expressed. Many of these have been a repeat of proposals that were tabled previously, and which, when they're carefully considered by the executive, were not favored from a policy point. So in a number of cases, submitters have said, well, we have a different view to the bill. This is our view. In some cases, it's the fourth time that a submitter would have raised that. And the only thing is that there are different policy choices. And what is before the committee is a policy choice that has been made by the executive following all of this consultation. In a number of cases, we've taken into account views expressed by the business community. In other cases, views by labor, views within government, views from the public comments. One of the concerns relates to shareholders having a right to vote on the remuneration report. I want to make the point that there are views that have been expressed that we need an even stronger regulation on the right to vote. Others seek to moderate the provision. In the original memorandum that we published in 2021, asking the public for comment, we set out in a lot of detail what the public concerns on the pay gaps were, as well as research findings on legislative and other measures elsewhere in the world. So the reason I raise that, Chairperson, is we recognize that there are different points of view with some of the submitters not taking a similar view to what has come out in the bill. But at the end of the day, we have to make these policy choices. The amendments that's proposed in the bill, in our view, are required to tackle the injustice of excessive pay. The pay gap has been a historical challenge in South Africa and a contributor to the country's inequality. Now, if the Select Committee and the NCOP supports the bill, it would mean that the new amending act will allow for stronger shareholder governance on excessive directed pay, and for company shareholders and stakeholders to be aware of, and if it's necessary, address unsustainable pay discrepancies. The issue of disclosure has become a critical theme, of course, not just in South Africa, but globally. And it's evident that the trend is towards greater disclosure. We now live in a world where this kind of information is becoming something that companies are required to make available more generally. Even in South Africa, the King report on corporate governance states that, and I want to quote precisely here, the remuneration of executive management should be fair and responsible in the context of overall employee remuneration. It should be disclosed how this has been addressed. This acknowledges the need to address the gap between the remuneration of executives and those at the lower end of the pay scale, unquote. Now, if we disclose executive remuneration in the pay gap, it can help companies and shareholders to assess whether directors' remuneration is fair and responsible. I can take the committee, if it's necessary, through the back and forth between different stakeholders as we try to find a balance that we thought still gives effective guidance to companies and to the market, but at the same time takes into account the views of everyone. And the balance package says that the level of voting required to approve the remuneration policy must be set at 50% plus one. So it could have been higher. But at the end, we came to that. Second, it says that the vote should be binding. It could have been voluntary, but we made that policy choice. Third, it said that the remuneration should cover the entire package, including bonuses. And fourth, it said that directors who serve on the remuneration committee and whose report is rejected must have consequences. And those consequences must be spelled out in the Act. The amendments, there were also amendments made. I thought I should bring it to the attention of the Select Committee that when we were at the Portfolio Committee process, we also received a number of proposals, and we took account of some of the original concerns raised by the JSE. And they also helped to amend the very original bill that was published. So by the time it came to the Select Committee, we've already taken into account those original concerns raised by the JSE. The further comments that has been made, in our view, are not strictly necessary for the legislation to be effective, and they intended, in their view, simply to improve clarity in the bill. In the department's view, the current wording, together with any necessary regulations or guidelines published by the CIPC, can address concerns raised. We gave consideration on whether we should add additional categories to the remuneration disclosure requirements. Honourable members will recall, I think it may have been Honourable Moimang who raised the question at the committee meeting last year, but it was certainly raised by committee members last year, that there could be other categories. From a policy point, as I said in the committee last year, I see the value of gender ratio disclosures to address that pernicious form of discrimination in the labour market. However, for something as important as that, it would need to be ideally advertised for public comment by the department, and I would want those kind of proposals to be considered by NEDLAC or the Standing Committee on Company Law. And when we've taken all of that into account, we felt that the package before the committee does take the discussion and the policy direction a very significant step further, and that we can always, in future amendment processes, address further changes. I've also covered last year in the discussion with the committee the subcontracted workers, where there is an opportunity in future to further improve these provisions. I've taken note of some comments on the Social and Ethics Committee, including Section 72, and make the point that the Social and Ethics Committee is an innovation in our law, that they address environmental, social, and governance concerns that societies have, and that the provisions in the Companies Act which apply to these committees really is there to give a nudge to a company to comply with these social and ethics considerations. These are environmental matters, they're governance issues, and so on. A number of features contained in the bill really are there to improve the workings of the Social and Ethics Committee. Some of the concerns relate to proposed amendments that deal with the composition. Others say, is it really the shareholders that should elect SEC members? And they give their reasons. We've given that consideration, and we don't see merit in the concern, as the Social and Ethics Committee has a very specific, and I would say rather unique statutory role. And we don't see how a shareholder-appointed SEC can negatively impact on that. There were a number of amendments that were proposed, Chairperson, that relate to matters that are not currently in the bill. For example, proposals on, I'm told by the department team that they include Section 5 and 66 and 69 and some different matters in 75, 129 and 145. All these proposals, even when there are some really useful ones, will need further research and public consultation, and they can be included in a future round of amendments. I noted the comments that were made on public interest thresholds, and I would refer to the remarks that were made in the previous meeting that I had addressed of the Select Committee, where I had that slide on public interest thresholds, and I spoke about it. On the company second amendment bill, honourable members, we take note of the fact that the comments have been a lot less extensive than on the primary bill. The two submissions that were received that disagreed with the proposed new changes under Section 77(7) said that in their view, the matter should be dealt with without limiting the general applicability of the Prescription Act. With respect, honourable members, this is simply a different policy choice, and not one that the department believe is warranted. There were proposals on language improvement in Clause 2. Again, we looked at it and we felt the bill as it stands, in our view, was sufficiently clear that there's always a possibility to further amend it. But in this case, we didn't think that it met the necessity test. Was it strictly necessary to give effect to the meaning? We didn't think that was the case. Chairperson, we did provide a more detailed document, and if it helps the committee that we run through that detailed document that we did last night, which sets out clause by clause the various proposals that we received, then I can ask the team to do so. But what I'd wanted to do here specifically is address the big policy issues. A lot of the other areas are refinements and a view that says, look, if I had to draft it, I would draft it differently. This is how I would draft it. But it doesn't point to an inherent flaw from a policy point of view or from a drafting point of view in the bill. So I want to conclude my broader remarks, Chairperson, by saying the proposals in the bill constitute an important form of our reform of our company legislation. And the bills have gone through very extensive engagement, public engagement. I've spoken about that. I also pointed out last year that the company's second amendment bill arose from the recommendations made in the Zondo Commission into state capture, and that, of course, was an open and public process. There were a few proposals made during the public submission process that require additional thought and an opportunity for broader stakeholders and NEDLAC to comment. We've taken note of those. They don't invalidate what's in the bill. In some cases, they seek to strengthen it. In other cases, they seek to raise matters that fall completely outside the bill. But we've taken note of that. So, Chairperson, in light of that, I would, subject to your guidance, wish to see if there are specific submissions that, in the committee's view, are not adequately covered in either the submission of last night or alternatively by the remarks that I have made. I would also want to ask if the committee would want to be taken through the document that was tabled last night to members of the committee. There's many people that we need to thank for getting this far. Of course, members of the committee themselves. I'd also want to appreciate the work of Professor Katz and his statutory committee. They've given advice on the bill, and how they derive that advice is as the Companies Act gets implemented, they monitor where there are problems and challenges, and they discuss it in their committee, and then they would make recommendations to the ministry, and in time we would compile all of these into an amendment bill. So this won't be the last amendment bill that Parliament will look at. Company law is dynamic, it keeps changing. And so I've had to rely on the insight, the expertise, and the advice of the committee, standing committee. And I will ask on some of these specific matters, Chairperson, that Professor Katz be given an opportunity to brief the committee on the discussions and the considerations that inform their advice to ourselves. So, Chair, that sets out the frame. What we now then dealt with is on a clause-by-clause basis, the document that we've presented or circulated to the committee goes into each clause, what it says, and the view of the department on that. I hope this has provided at least a framework for the response, Chairperson, that the committee can look at when it considers the document that was circulated. So, Chair, if you would like, I could get the department and Professor Katz to make some specific remarks, or I could leave it now to you, Chairperson, in your wisdom, and the committee to guide on any specific areas that you have wanted us to deal with. I know the parliamentary legal advisors would be able to comment on lawfulness issues, so I have not specifically dealt with those. I've tried to deal with policy issues. I have, in a number of cases, said that there were specific proposals that just had an alternative drafting logic, but that didn't invalidate what is before the committee. And I've also said some of the proposals fall outside the scope of the bill itself. Thank you very much, Chairperson, and over to you.
Thank you very much, Honourable Minister, for the overview and clarifying some of the policy matters. What I normally used to minister that the department would, together with the Constitutional and Legal Service Office, would develop a document with clause-by-clause response on what has been submitted by the stakeholders. That document would include the response of the department as well as the response of the CLSO, which is the Constitutional and Legal Services Office, so that we clear what each of the stakeholders said on a specific clause or section, and what is the response, and that assists then for us as members when we do deliberations. So even the document that you're referring to, that you're asking that we be taken through it, I would rather suggest that we be provided with a detailed, I think Dr. Mosoja would, DDG, was involved in the legislative process regarding the copyright amendment bill as well as the performance protection. So we would appreciate if that kind of a format, because it makes it easier for members to follow and understand the issues. So it would be late now to allow the department to do that now. Without first members having received those documents. Because even myself, last night, there was a load shedding that started at 1800 hours until 2100 hours. So I noticed that when I woke up this morning, the document was only sent to members, I think after 8. I just this morning been able just to browse through, not in detail. I could not apply my mind to the document. So I would rather suggest that perhaps if members, with the overview that the minister has just made, if there are questions for clarities, they can do so. And also maybe Professor Katz could come in and clarify some of the issues. Because last week he wanted to clarify the point that was raised by Honorable Brataset. Maybe it's his opportunity now to clarify that part. But then I would suggest that honorable members, we combine the clause by clause presentation, the document that will be forwarded to us by the department. We combine it with the deliberation. Yeah, so that's what I would like to propose. But first, we get the members to ask questions for clarity on the overview and the policy clarities the minister has provided. After that, I don't know if Advocate Ibrahim would like to come in now, or you come in when we receive the detailed document. Maybe let's start with you, if you can make your comment now, whether you want to come in now with your presentation, or you want to come in when we deal with the detailed document from the department.
Thank you very much, Chairperson. Chairperson, I will take my cue from the committee. What I have done, because I did not have the benefit of a matrix clause by clause, is that I picked up on the main legal issues, particularly the ones concerning the constitutionality, clauses relating to the privacy right, and then also other smaller ones that up from the submissions. So if the committee would like for me to take them through some of that, I'm happy to do so. Chair, it might assist in the question.
Sorry, Advocate. That's a minute, Advocate. Professor Katz, can you please switch off your mic? Okay, sorry for that. You can continue, Advocate.
So, Chair, I do have a high-level presentation that I would be willing to do if that's going to assist members for when we get to the actual clause-by-clause deliberations. But I'm completely at the direction of the committee in that regard. Thank you, Chair.
Thank you so much. Perhaps because we have not had sight of that document as well, it would be proper if we could get it maybe as soon as possible, so that when we then deal with the clause by clause, we have had sight of all these documents. Honorable members, any comments? First, that we get clarities on the presentation that have just been made by the minister in response to the submissions of the stakeholders. The two, that next week then we'll receive a detail. Sorry, not next week. I think the committee secretary will indicate, because I understand next week we're dealing with the small business development. But the committee secretary will indicate when we are meeting again with the DTIC on these two bills. When we meet, we will then have had an opportunity to go through the responses and clause by clause, discuss and have seek clarity questions also on that detail, as well as deliberating. But that will also include the presentation that will be made by Advocate Ibrahim. Any comments? Honorable Mima?
Thank you, Chair, for the opportunity given to me. The second is to appreciate the overview by the minister on those key policy issues, the issue of privacy, and also the issue of the remuneration. On section 26, I think on the document sent to us, the department says it does not recommend changes, but there is a typo error in section 26(5)G, and the correction of the word from, I think, the spelling mistake of contemplated. So I just needed clarity on that, because I thought this one, the department will agree that the spelling is corrected from contemplated to contemplated. So I think it's one of the areas that I detected. So if one could just get clarity from that, but I suspect it's a matter definitely that the matrix, it would also have got the attention of the CLSO, because this one definitely need correction, because it's a spelling error, it's just a typo error. And then I think on the issue of remuneration, I think one must appreciate also the context and the overview that the minister gave, because I suspect it's a new terrain to traverse from ourselves as a country. But I think an appreciation must be given with more information that was made around making a comparison between various jurisdictions around the disparities in relation to the pay inequality between the ordinary workers and also the CEO. It reminds me of one of the local mining whose partners is listed in Australian Stock Exchange. In October 21, the outset, the chairperson, after the shareholders, how it is represented, after the shareholders rebelled against executive pay, the shareholders of that mine did not approve the remuneration report, and they did not only just remove the chairperson, they also voted in favor of a resolution to remove the CEO. And it's I think the context and the overview that the minister gave speaks to what is happening in other countries, and therefore it is a necessary intervention because then it happens in other jurisdiction, and what is important. What is important is it underlines the importance of the remuneration report to the shareholders, whereas from some of the presentation that was received, they wanted to restrict it to the board, to say, look, it is the board that normally deals with this matter. But I think what is quite important, it underscores the importance of the shareholders' role at annual general meeting when it comes to the issues around the remuneration arrangement. So I think one must appreciate that. And lastly, I think on the issue of the suggestion that the chair made in relation to the metrics, to augment, I think the overview by the minister on the policy matters. I think that will help, but also the minister's overview make things much more easier in terms of the next presentation that we'll receive, because I think one of the issues that the minister has suggested was that the officials can present that, though obviously it will not have the metrics will not be complete because you do not have received also the input from the CLSO. Thank you, Chair. But I think that's the last point. I think what is also important is I think on the report is the last paragraph where the department says that overall, in terms of recommendation to the committee, the department does not recommend any amendments from section 1, 16, 25, 33, 45, 118, 135, 160, 194, 195, and also 204. That is the thrust of what the document says. But obviously, that metrics will make it much more easier for us to be able, in terms of tabling the report the report that the committee must adopt, and also the report that the committee must recommend to the House for adoption. Thank you, Chair.
Thank you so much, Honorable Muimang. Honorable Dango, Ambassador.
Yeah, thank you very much, Chairperson. Chairperson, I'm not going to speak to substance, but rather to process. You had indicated a process as to how to take this forward, and I think we should take that kind of advice and take it forward in that particular manner. That the information inputs today from the various entities and from the ministry and from Professor Cass and others should be given to us today. That we would discuss substance after we have received the documents and consider the legislation and the processes then. And this is my suggestion, that we take the guidance that you have provided onto the way forward earlier, and not debate substance at this particular point in time. Thank you.
Thank you so much, Honorable Dango. I've just been advised by the committee secretary that next week, as we'll be dealing with the small business development, their there it will be the responses also, because there were no oral submissions, presentations. They were just written submissions. It is of the view that that meeting will be short, so we can therefore still have the meeting with DTIC next week, Tuesday, to continue with the clause by clause clarities and deliberation for next week, as well as the input of Advocate Ibrahim for next week. I'm also responding to you, Honorable Lord, the question that you put on the chat. I also understand that the clause by clause document is ready with the department, so we will request that if it can be given to the committee secretaries today, so that it can be circulated to all members, so that they can then engage the documents and be ready to participate next week on Tuesday. Perhaps the other clarity, maybe that's what perhaps the CSLO should advise, the CLSO should advise this typo on contemplation, whether it will constitute an amendment or just a correction of that typo. Would it be regarded as an amendment, and therefore it should then go back to the NA? Perhaps if, as you will be presenting next week, if you can then take that into account. The other question as well, but to the minister, there's issue of of the holding companies that could be, in terms of this law now, they could be allowed to assist financially its subsidiaries. There was a question from the I think Consumer Goods Council as to, or in fact, they wanted that to be extended further in the law, that even the companies themselves should be allowed to assist one another financially. It should not only be the holding company that do so. I see that the response is the focus is more on the reducing the compliance burden. It's not about the issue of the companies assisting each other financially. But if the focus is on a reduction or ease of doing business, can then the companies, even if it is not now in the law, can they assist each other? I think that would be perhaps the question that they wanted the department to make an amendment that specifically allow companies to assist each other, under that holding company, not that the money should come directly from the holding company itself. Without the department now accepting that proposal, but its focus is only on ease of doing business, reducing the issue of the burden of compliance. But does it give them room to companies to assist each other financially if one company is having difficulties? But then on the issue of the definitions, I see that in the documents you can't be defining everything. There in the 2008 on the definition of securities, it included it says the security means shares or debentures or other instruments. One of the stakeholders wanted that or other to come back. Other instruments. Is there any reason why it is being deleted? Because according to them, it would have covered all the other, like it is mentioned in the response document from the department, the issue of bonds. Bonds therefore would fall under the other instrument. Is there any reason why that isn't deleted? Thank you so much. Back to you, Honorable Minister, and I also Advocate Ibrahim was ready to make some responses as well, but we'll allow it after the Minister. And your Minister, over to you.
First, thank you very much, Chairperson. What I propose to do is I will come back to specifics, but I want to start first with the broader suggestion or proposal you've made, and we would be very happy to expand the matrix and include the information that you've requested, which could be then helpful to the committee. So if there's anything else in addition to that the committee could find helpful, please do let us know, because it would make the work of the committee both easier and more productive if we provided this kind of information. So thank you for giving us that opportunity. On there's a few very interesting and specific questions you've asked, which I will respond to. But perhaps I can start by giving Professor Katz an opportunity. He may want to comment on the definition of securities issue. He may also want to talk through the holding company and affiliates clause, although I will then come back to that. He may want to make some remarks on specific issues that came up in the public comment, where I understood, as you said earlier, Chairperson, you would like to give him that opportunity. Similarly, on the questions coming up from Honorable Moimang, I will seek to address the question of international practice, but Prof. Katz has also had in his work exposure to that, so he may want to comment on that. On the matter raised by Honorable Moimang about the typo and the department's submission, I draw attention to the second last paragraph of the department's submission that they circulated last night, that said, aside from support to address typos and proofing edits, such as setting out words in lowercase rather than caps. So those are matters that the department is not dealing with, because they're really just administrative matters that don't go to our policy role, and we would leave that administratively to Parliament to address. So that's the view of the department in relation to that. Can I then, Chair, through you, give Professor Katz the floor, and then I'm going to come back and respond to each of the issues that were raised.
Okay, Minister. Yeah.
Professor Katz, if you're able to take the floor.
Yes, thanks, Minister. Thanks, Honourable Chair and honourable members. Thanks for this opportunity to address you. That is very much appreciated. Let me just start with the two, Honourable Chair, that you raised. The one on the request to reinsert other instruments. Honourable Chair, that's given rise to many problems in practice, because the definition of securities arises in a number of sections in the text. Let's say, for example, section 49, 99, when a company offers securities to the public, it requires a prospectus inter alia. So the definition of securities became very important. And there were people who said it includes the word other instruments, includes shareholder loan accounts, and includes a variety of other issues which really would be inappropriate and confusing in the text in which the word securities is used. So it was for that reason, to eliminate that problem, that other instruments was taken out and securities is confined to shares and debentures. Because where securities, to be repetitive, is used in the text, for example, offers to the public, it's clear that what's in mind are shares and debentures. So that was a deliberate decision, Chair, based on the factors I've just mentioned. If we look at section 45, Chair, and I'm going to be, with your permission, a little more expansive. Section 45 deals with the prohibition against giving financial assistance to companies within the same group. And if you want to do so, it's not an absolute prohibition, but it requires a special resolution passed by the shareholders not later than the last 2 years. And secondly, conducting the solvency liquidity test. So what was the thrust, the policy behind section 45? Where a company, let's call it target company, has a holding company and outside shareholders, minority shareholders, then when target company gives financial assistance to its holding company or to its fellow subsidiaries, namely those subsidiaries of its holding company, it could be detrimental to target company's minority shareholders. So it was the protection of the minority shareholders to which the policy of section 45 is addressed. Now, when a company gives financial assistance to its holding company, it could be to the detriment of its own minority shareholders. If a company gives financial assistance to a fellow subsidiary, that's a subsidiary of its holding company, the same potential for prejudice to the minority shareholder. But in the case where a company gives financial assistance to its own subsidiary, there is a complete alignment between the interests of all shareholders. So it was unnecessary to have that prohibition, and that prohibition being unnecessary also complicated the ease of doing business. So when we say the policy objective was the ease of, for the amendment was the ease of doing business, that was the subsidiary objective. The objective is still to protect minority shareholders, but where minority shareholders don't require protection, in the case of financial assistance by a company to its own subsidiaries, then it's serving no rational purpose and it's harming the ease of doing business. So I just wanted to give that perspective there, Chair, and the suggestion that it should apply to all financial assistance throughout the group overlooks the policy objective of Section 45, the protection of minority shareholders in all cases other than when the company gives financial assistance to its own subsidiaries. So, Chair, those suggestions about amending Section 45, with great respect, are incorrect and would undermine the total logic and policy objective of 45. There was one other suggestion, Chair, about 45, and that is we're now proposing, DTRC is now proposing that the prohibition against giving financial assistance to a subsidiary be abolished. But the word subsidiary is a South African subsidiary, because our Act regulates South African companies. The issue that was raised by some commentators was you might have a foreign subsidiary, so it wouldn't fall within the definition of subsidiary, but colloquially, it would be a company controlled by its holding company. And the request there was, why don't you allow in your amendment that it shouldn't be confined to South African subsidiaries, but should apply to foreign subsidiaries, quote unquote. The answer there, Chair, is complex but clear. And that is, a foreign subsidiary is regulated by the laws of the foreign jurisdiction that may have totally different approach to the exercise of control and all of that. So we couldn't bring into our dispensations the activities of the foreign companies that are owned by South African. So, Chair, with great respect, both suggested amendments have not been accepted by the department for very good company law reasons. Then I've dealt with your other question. Then, Chair, if I may, Honourable Browderseth, in the meeting that was held last week, raised a question, and I sought to answer it, and you correctly ruled that that was not in place, and I apologize then, and I again do so now. What I wanted to say, the thrust of Honourable Browderseth's question is, by bringing in those companies in 24 and 26, where there's access to their financial statements, etc., isn't that in increasing the compliance burden? Why don't you not do so? And I think the Honourable Minister has clearly given the answer to that, that in the context of transparency and accountability, there's no distinction between public, private, public, state-owned, and certain private. And the certain private are those whose public interest score exceeds the prescribed level. So those private companies, Honourable Browderseth, whose public interest score doesn't exceed, there the department has been concerned not to be increase their compliance burden. So while preserving the general approach to transparency and accountability, public, state-owned and private, there is a small carve-out in recognition of the small private company whose public interest score doesn't justify the compliance burden for accountability purposes. So I think the department has taken that into account. Chair, there's just one other that I would, two others if I may, with your permission. There were some suggestions about the transition period, particularly in the new compliance, the new disclosures in 30A and B, and listed companies there may be in the middle, just about to give their notice to shareholders. The Act becomes operative and they have to start again. That's one example where one needs sensible transition. Another one is in the amendment of the private company portion of regulated company in section 118. You yourself, Honourable Chair, mentioned last week that there would be provision in the proclamation that brings into effect the Act staggered dates, taking cognizance of the necessity to make regulations, etc. So I think, Chair, you'll see that from the department's responses, any suggested amendments to provide for transitionary allowances isn't appropriate in the bill itself. It would be taken into account in the proclamation, bringing into sections of the bill, and as the Minister has explained, that could be on a staggered basis. Chair, just one last point. The Minister, sorry, two, if I may, you've asked, will this disclosure, as required by 30B and the existing 30 with the naming and that, have the desired effect of reducing remuneration? I don't think any jurisdiction who's done the same as we propose to do will tell you categorically that it has that effect. But in a very famous book called Other People's Money by Justice Louis Brandeis of the United States Supreme Court, when he dealt with the virtues of disclosure, he said, electric light is the best disinfectant, sunlight the best policeman. And what he says is that why he makes that observation is that that kind of disclosure obligation has what he calls a shrinking effect. People don't want to have to defend and justify outrageously disproportionate remuneration. So the very requirement of putting it in the sunlight shrinks. Now, I'm not saying for one moment, Chair, that that is always the case, but that's the philosophical objective of regulation by disclosure. And then last point, Chair, the Honourable Minister has said that some of these proposals were based on linguistic style, every draftsman, but some, Chair, with respect, are also based on, if I may respectfully say so, misconceptions of some underlying provisions of company law. I've given you the ones on Section 45, the two misconceptions. I've tried to give on other instruments where it has its adverse impact. So there was one, Chair, that dealt with offers, mandatory offers when there's a change of control. And the question was, well, if someone's shareholding goes above 35%, but it arose because there was a buyback of shares by the company, that shouldn't trigger the consequence. Chair, there's a very good reason why it does. The whole philosophy of mandatory offers is based on the doctrine of equal opportunity when there's a change of control. And the control could change in one of two circumstances. Either a company and its consorts together acquire more than 35, or the company, by buying back some of its shares, could then bring about that one of its major shareholders, who had 33 or 34 before, now crosses the line. And if that was exempt, that would have been a very big hole, a very big lacuna, that control could change without an offer, and that shareholder could thereafter buy as many shares as they like. So again, I say, Chair, with respect to Honourable Ministers, clearly correct in saying Some of these amendments were motivated simply by linguistic style, and every draftsman has his own style, but the effect is the same. Some, Chair, with respect, are based on incorrect analysis or seeing what the logic is from a company law point of view of many of these provisions. So, Chair, thanks to you and your colleagues for giving me this opportunity to make some of these general comments, but may I hand back to the Honourable Minister.
Well, thank you very much, Professor Katz. And in fact, you've dealt so extensively with some of the issues that my burden of response is lower. I'm going to start with Honourable Moimang's comments on international practice. And Honourable Moimang points to the example of Australia, where the shareholder response was noted by him. Now, what we're trying to do here in the bill, and this is quite an important issue, is we had the option of either the state regulating how these matters should be dealt with on remuneration, or we had an opportunity to empower shareholders. We took the route of the shareholders. It does require an active shareholder approach to these matters, and that raises the question then of the proper responsibility between a board on the one hand and shareholders on the other hand. Traditionally, in many countries, remuneration matters were largely or exclusively the domain of the board, and shareholders would not get involved in it. But what has happened is those practices have resulted in differentials that shareholders have expressed a growing concern about, and they limit it now simply to advisory votes. In addition to shareholders, society has raised concerns about it. We have these periodic stories about salary levels more than 100 million rand per annum, or 80 million rand per annum, or these kind of headline catching ones, and it leads to a round of public commentary and condemnation. The role of Parliament really is to, and of the executive, is to take heed of these public concerns and find an appropriate balance from a policy point of view of addressing it. So we've sought to address it by empowering shareholders and ensuring that there's consequences to remuneration committee's decision. And I wanted to just highlight that difference, and that the reason why shareholders are now given additional, if one wants, powers in this respect, Honourable Moimang. On the matter raised by Honourable Khai on holding companies and affiliates, I think Prof. Katz has dealt with the matter so substantially that I will not seek to add to that. On the matter of definitions and the exclusion of the word other, I think he's again dealt with it substantively, and I need not comment on that. I hope, Chairperson, that does respond to the different issues that came up now. We will make available the additional document as requested, and will also be available. The committee can draw on the officials of the department at your pleasure, Chairperson, and subject to his availability, the Chairperson of the Standing Committee on Company Law, which is a statutory body on these matters. I will then hand back to the Chair, unless I have dealt with the typos issue, unless there is anything, Chair, that you believe I may have missed that I should perhaps just briefly return to. Thank you, Chair.
Very much, Honourable Minister. I think you've clarified all the questions, and also thanks to Professor Katz also for clarifying the questions. Perhaps this one would go to Advocate Ibrahim, the one of typo, whether it constitutes an amendment that should then go back to the NA. Would you like to comment on that, Advocate?
Thank you, Chairperson. Chairperson, my presentation that I prepared for today did in fact cover that issue. The Minister is 100% correct. It will be dealt with as an administrative matter. So all we would do is, together with the Parliamentary Bills Office, is make that correction before it serves in the Council for adoption. Thank you, Chair.
So it won't constitute. Let's say if we don't have any amendments at all, would that typo be constitute an amendment?
No, Chair, it won't.
Oh, okay.
We will correct it on the version that then gets sent to the presidency if there are no changes.
Okay.
Thank you.
No, clear, because I was when I saw that in my mind, I was thinking whether that would then constitute an amendment that must go to the NA. Thank you for clarifying that. Let me also again, I've been informed that the document, the detailed document, I think it's a 53-page document, according to the committee secretary has received it. She also advised that because it's a long document, we won't be able to do the deliberation on the same day. We'll just be taken through the document. We ask questions for clarity, and also on that document, as well as the document that Advocate Ibrahim will be presenting. Then the following week on the 12th, we'll then deal with the deliberations, honorable members. If there are, let me find out first if there are any other questions for clarities from members and any other comments. It seems not. Honorable Minister, I don't know if you want to make any closing remarks, and also wish you well in the WTO MC13. We hope there will be better outcomes the way than they were previously. We appreciate the MC12 outcomes. We hope that you'll do more in the MC13.
Well, first, thank you very much, Chairperson, and also really those words are very warmly received. If I wanted to conclude, the most appropriate one would be to say that the Companies Amendment Bill has gone through a very extensive process, and it's been very interesting that in that process, we've also had some interesting proposals that have been made by a number of people that go beyond the scope of the bills, but that will inspire a new program of work that the committee will be advised of in the form of a bill that may come out in the new parliament, the 7th parliament. I should also indicate that the processes that the Select Committee has followed has been very, very helpful, and I wanted to appreciate, Chairperson, you and the committee members for the really excellent spirit of engagement with the stakeholders who have made comments. There's been a lot of praise for the work of both parliamentary committees. And as the executive, we also are proud of how our parliamentary processes have engaged on this bill. I think the market and the business community would be very keen that we conclude the two bills. They would bring legal clarity and certainty to these areas that we have needed to do as a package of reform, where there have been anomalies and challenges with implementation of the Companies Act as it stands. And so finally, my thanks then to both Professor Katz and the members of the Standing Committee on Company Law, and to the department officials. We look forward to getting the bill considered by the committee at its next sitting, and we will take into account. We may, if necessary, add to or amend the document we're going to circulate to take into account further the comments that came up here today in the session. For example, the points about holding companies and affiliates. We may want to put a paragraph or two into the document, Chairperson, to just give you that additional scaffolding of a written paragraph or two in response to your question. Similarly to Honorable Moimang's question. So I will get the document that we have sent. We may then send out an amended version fairly shortly today. So I'm going to ask that one not yet be circulated, so that we can give you the benefit also of a written reply to the questions that have come up today. Thank you very much then, Chairperson, and I look forward to hearing the outcome of the committee's deliberations next week. Chairperson, we just need to ask that you unmute.
No, sorry, I wasn't aware that I'm muted. I was also thanking you and the team for making time. We know that you are busy out there in Abu Dhabi. Thank you for making time to be available to take us through on the responses to the submission that were made by our stakeholders. Thank you very much. As you say, we will make you aware of the outcomes as we continue with the consideration of the bill. We set aside this period for just these two bills, the bill of the DTIC, as well as the bill of small business development. There's nothing else but just those two departments that whose bill will be considering. So we will update you on the processes. Thank you very much. You are now released. We will just deal now with the internal committee matters. Thank you so much.
Thank you very much, and thank you to members of the committee.
Thank you. Bye-bye. Committee Secretary, I don't know if we are ready with the adoption of the minutes.
Yes, Chair, if I can just hand over to Enrico to flight. There's about 5 sets in total of minutes that we need to adopt.
Okay. Do we still have the quorum?
Yes, we do, Chair.
Okay, thank you so much. Mr. Baziak, can you please scroll down? Thank you very much, Mr. Pazzi. Honorable members, we've just cited the minutes of the 5th of December. It was a meeting that we were receiving the briefing on the very bills that we are dealing with right now. Are there any corrections, honorable members? If there aren't any, can we have a mover in the adoption of the minutes of the 5th of December, 2023? I don't know if there are any hands, Ms. Madi.
Chair, Honorable Moimang has raised his hand to move.
Oh, okay. Thank you for assisting me. Honorable Moimang.
Thank you, Chair, for the opportunity. With the minutes as presented, Chair, I formally move that they are adopted as a true reflection of what happened on the 4th of December. Thank you.
Thank you so much. Honorable members, are there any seconders? Or is there any seconder for the adoption of the minutes? Is there any hand there?
I don't see any hands, Chair.
Okay. In that case, then I will second the adoption of the minutes. Is there any counter view? Not. Can we then?
I couldn't
take-
come in, Chairperson. There was a problem with
Eh,
so thank you for seconding it.
Oh, okay. No, that's right. Thank you so much. The next set of minutes, Mr. Bazia. This was a meeting of the 6th of February, 2024. Those present can take note. Present from the department. Delegation was led by the minister and the officials of the department, the support staff. By the minister. Presentation on the compensation fund and the UIF. And members then deliberations on the presentation. And ask questions for clarities. To then close at 11:25. Are there any corrections, honorable members? If not, can we have a mover and the seconder for the adoption of the minutes of the 6th of February?
I so move, Chairperson.
Thank you very much, Honorable Dango. Any seconder?
I so second, Chair.
Thank you very much, Honorable Moimang. Is there any counter view? Not. The minutes of the 6th of February have been moved and seconded. I think there was another set on the same day in the afternoon.
Correct, Chair. Correct.
Yeah. Over Over to you, Mr. Bazia. This one was a briefing by the Department of Small Business Development on National Small Enterprise Amendment Bill, but also the adoption of the committee program, as well as the tabling of the correspondence from the Western Cape Legislature. The members were present, and the department led by the minister, and also officials of the department and entities. The support staff. So explain this was about the briefing. It was introduced by the Minister of Small Business Development. Okay. Any corrections, honorable members? No
Correction, Chair.
Okay. Can we have a mover and a seconder for the adoption?
I formally move
Oh,
for the
thank you very
adoption
much.
of minutes of the 6th of February
I
that took place
I
at 2
second,
o'clock.
Chairperson.
Thank you so
I
much.
second, Chairperson.
Thank you so much, Honorable Ambassador Dango. Any counter view or motion? If not, so the minutes of the 6th of February that was held in the afternoon have been moved and seconded, so they are adopted. Over to you, Mr. Bazia. This one was on the 20th, which was last week, where we're considering the submissions from the public, our stakeholders, on the Companies Amendment Bill, B27B, Section 75, and Companies Second Amendment. Those were the attendees. Stakeholders, parliamentary staff. Thank you very much. Are there any corrections? No corrections. Can we have a mover and a seconder for the adoption of the minutes, the 20th?
I so move, Chairperson.
Thank you very much, Honorable Ambassador Dango. And the seconder?
I can't second, Chair, because I had apologized.
Yes, I'm aware you joined in the afternoon. Okay, in that case, if there's no
Chair, it's Honorable Boshoff, I second. Thank you. The proposal.
Thank you so much. Thank you so much, Honorable Boshoff. Any counter motion? Not. So the minutes of the 20th have been moved and seconded. And then I think on the same day, in the afternoon, we had another meeting on WTO agreement, AOO. Okay, if you can scroll down, Honorable Azia. Okay. Thank you very much, Mr. Bazia. Are there any corrections, honorable members? If there are no corrections, can we then have a mover and a seconder for the adoption of the minutes?
I move for the adoption, Chair, because I attended the afternoon session. Thank you.
Thank you very much, Honorable Moimang.
I will second it, Chairperson.
Thank you very much. Any counter motion? Not. Thank you so much. I think that was the last set of minutes. I'm happy that we have been able to deal with all the minutes. I was getting worried that we might have, before the end of this first term, we might be having quite a number of minutes that have not been adopted. I'm happy that we have now adopted all the minutes. Thank you very much. I don't know if Committee Secretary, if there are any announcements.
No, Chair, and none other than our next meeting is next week, Tuesday, on the 5th of March.
Okay. So next week, Tuesday, we start with the small business development honorable members. They will be responding to the written submissions. There are 5 of them. And after that, immediately after that, then we will deal with the 53-page document that the committee secretary will be circulating if it's not yet been circulated. But the minister has also indicated that they will be also amending the document to include some of the issues that came up during our questions and answer session. Thank you very much, honorable member, for attending the meeting and also for your participation. We'll see each other virtually this afternoon. There are quite a number of bills that will be tabled. But as a committee, we'll also be tabling this WTO international agreement ratification by the House this afternoon. Thank you very much. The meeting is adjourned.
Recording stopped.